This is the landmark case that every law student knows. A shopkeeper displayed a knife in his window and ended up in court for selling a prohibited weapon. The prosecution thought it was an easy win, the defence looked ridiculous, but the outcome was not what anyone expected. This is Fisher v. Bell. The case began in a small retail shop in Bristol. The shopkeeper, Mr. Bell, was the defendant, and the Chief Inspector of Police brought the case against him. This is because, one day, a police constable walked past Mr. Bell's window and spotted a flick knife on display with a price tag. He went inside, examined it, and took it away for inspection by a senior officer. When the police confirmed it was a flick knife, they came back to tell Bell he would be reported for offering it for sale, which was banned under Section 1 of the Restriction of Offensive Weapons Act, 1959, to which Mr. Bell replied, "Fair enough." Mr. Bell had effectively made an illegal offer to sell it. Simple, right? He displayed a knife, so he must have offered to sell it. But the law loves technicalities. At trial, the prosecution said the case was straightforward. Bell had a prohibited weapon in his window with a ticket behind it. In their view, these actions were carried out with the purpose of attracting a buyer and selling the knife. The prosecutor argued it was clearly an offer for sale and in breach of the law. Bell's defence took a different path. They agreed the knife was there, but they argued that at no time did he offer the knife for sale within the meaning of the Act. The judges said that because the 1959 Act didn't define what offer for sale meant, they had to use its normal legal meaning from contract law. And in contract law, simply displaying something isn't an offer, it's an invitation to treat. So Bell hadn't made a legal offer at all, and therefore hadn't broken the Act. The prosecutor appealed. But first, what does that even mean? What is an invitation to treat? When lawyers use the phrase invitation to treat, it sounds technical, but the idea is very simple. It means the shop is not offering to sell you something, instead the shop is inviting you to offer them money for the item. Think about a supermarket. When you see a price on the shelf, that price is not a legal offer, it's just information. The price tag simply tells you the lowest price they're willing to take. The real legal offer happens when you take the items to the till and try to buy it by making an offer. The cashier can then accept your offer or refuse it. Once they accept, that's usually when the contract's formed. Now imagine if the shelf label counted as the offer. Every time you pick something up, you would automatically accept that offer and create a contract right there in the aisle. And if you put the item back, the law would need complex rules to undo that contract every single time. Ordinary shopping would become complicated and chaotic. Take for example when I worked in retail. People would sometimes move sales stickers from one product to a more expensive one. If merely picking an item up was acceptance of an offer, we would have been forced to sell the item at that fake sticker price every time. The shop would have lost huge amounts of money. This is why the law says a display is only an invitation to treat. It's an invitation for the shopper to make an offer. It sounds like a small distinction, but it's what keeps everyday shopping simple. In the appeal, the court accepted that to a layperson it looked like Mr. Bell had offered to sell the knife, and arguing the opposite would be nonsense. However, any act must be looked at in light of the general law of the country, and it must be assumed Parliament knows the general law when passing an act. Therefore, it's perfectly clear that under the principles of contract law, the display of an article with a price on it in a shop window is an invitation to treat. The judge said Parliament could have easily written the law differently, and in other laws, when they wanted to stop people displaying things for sale, they used words like offering or exposing for sale, as that phrase clearly covers items shown in a shop window. But in this act, Parliament only wrote offer for sale. They didn't add the extra words. So, the court decided it had to stick to the wording as written, and that wording did not include simply showing the knife. The appeal was dismissed. Mr. Bell was not guilty. Of course, this wasn't actually what Parliament had intended, so to close the loophole, they later amended the law, adding new wording like exposes for sale or has in his possession for the purpose of sale. Fisher v. Bell became one of those rare cases that every law student learns by heart. It's remembered not for the crime, but the absurdity of the defence. It proved that the law often turns on the smallest technicality. Parliament may have fixed the statute, but Bell's name stayed in the textbooks as the man who exposed its flaw.